I saw a case that came out this week from the Appellate Division, Second Department. It's a personal injury case. And he saw something you don't really see a lot of in this state, which is a plaintiff, an injured person, moving for summary judgment. That would be essentially establishing a cause of action, establishing liability on papers with regard to a serious injury. As you may or may not know, in New York, in a bodily injury case and other no-fault cases, you have to meet what's called the threshold. And one of the threshold categories you sometimes see plaintiffs move for to seek judgment on is, they call it 90/180. And what that means is that you, as a plaintiff, were not able to engage in your regular customary activities for any 90 of the first 6 months, 180 days following the motor vehicle accident. But generally, that's usually met by someone not going back to work. That's generally the case law and in the practice of law, how that is met. So if one of these cases goes to trial, one of the things you would show is that you didn't go to work for 3, 4, 5 months following the accident. And then you would have medical evidence showing that you suffered a medically impaired, some type of disability, although non-permanent. So for instance, you would have a neck or back injury, which prevents you from sitting or from walking. And let's say your job is, landscaper, factory worker, cashier, one of those positions. You just can't work. You just can't stand, right? And you're out of work for 3, 4, 5 months, and you have medical records to substantiate that you just can't go back to work and that you do have this type of injury. Usually that would meet that threshold.